accordance with Section 5 of the Open Public Meetings Act, be advised that a notice of this meeting was made by posting on the bulletin board in Town Hall and forwarding to the officially designated newspaper that this meeting would take place at Town Hall at 7 p.m. on Tuesday, August 17th, 2021. Meeting details of the draft agenda were also posted on our Township website. Please all stand to salute the flag. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. May I have a roll call vote, please? Here. Here.
Here.
Deputy Mayor Wasserman?
Here.
Mayor Purvis? Here. Please be advised that the proposed ordinance 2581-21, ordinance 2582-21, and ordinance 2583-21, designating various historic properties in the township, are being withdrawn from consideration of introduction this evening and are scheduled to be considered for introduction at our September 1st meeting. May I have a motion to approve the agenda as revised? Motion. May I have a second?
Second.
All those in favor?
Aye.
Any opposed?
Aye.
Is that in favor? Sanjeev or opposed?
Favor.
Favor. Okay. May I have a motion to approve April 21st, 2021 Township Committee minutes?
So moved.
May I have a second?
Second.
All those in favor?
Aye.
May I have a motion to approve the May 4th, 2021 Township Committee minutes? Motion. May I have a second? All those in favor?
Aye.
Aye.
May I have a motion to approve the May 18th, 2021 Township Committee minutes? Motion. May I have a second?
Second.
All those in favor?
Aye.
Aye.
Tonight, we are confirming motion of a member of the fire department, and I'd like to introduce the fire chief, Echeverria, who will provide the background.
Good evening, Mayor Purvis, Deputy Mayor Wasserman, Township Committee members, Alex McDonald, colleagues, friends, and family. On behalf of the Melbourne Fire Department, we please accept my appreciation for the longstanding support that we received from you, the committee, and the community. It is my great honor and pleasure to be able to introduce the one candidate for promotion tonight, Jeffrey Wanamaker. Firefighter Jeffrey Wanamaker was born and raised in the township of Melbourne and currently resides in Sterling, New Jersey. Jeff is a second-generation fireman. Jeff's father, Jim, here with us today, retired back from Melbourne Fire Department in 1994. He joined the volunteer division in 1990 under Chief Terry Murray, the graduate of Melbourne Senior High School in 1989. Jeff was hired to the career division in February of 1995 and proudly served with his uncle, Captain David Marsh. In addition, he currently volunteers in the Sterling Fire Company in Longfield Township. Jeff holds many certifications, including Level 2 fire instructor, rapid intervention crew trainer, surface ice rescue level 1 and 2, boat training, CPR instructor, and many other courses. Throughout his career, he has been highly involved in the township's fire prevention education programs. In addition, Jeff has been a proud department chairman of the Aluminum Cans for Burn Children program, which is in partnership with the St. Barnabas Burn Foundation. He's also involved with the Melbourne Firemen's Welfare Association. Jeff, along with other members of the fire department, responded and assisted in the 2001 rescue and recovery effort at the World Trade Center, working with FDNY and multiple agencies in all aspects for several days. Here tonight with Jeff is his wife, Tracy, and his daughter, Catherine and Addison, family and friends. Captain Wanamaker will be assigned to the Melbourne Fire Department Fire Prevention Bureau. Mayor?
May I have a motion to approve resolution 21-220? Motion. May I have a second?
Second.
All those in favor?
Aye.
Gaddy, will you please offer the
Congratulations.
Thank you, Mayor.
Take a few minutes if anyone in the room would like to leave the room, fire department. So, a little bit out of order and introduce Rocktoberfest Chair and Co-Chair. If you'd like to come, Chair and Representative, if you'd like to come and present to the township.
Thank you so much. Joanna Parker-Lentz, Agnes Sim. We are representing Oktoberfest this evening. We are super excited for you guys to consider our event. So we are fifth year, even though we're spread apart over a 6-year period, but our 5th year anniversary last year. We are very excited to spread the cheer on September 18th. It's lovely. It's a couple here. We are super excited to present. At this point, we have 31 sponsors that are really kind to us. We are looking for double that. Our fundraising efforts just started, so anyone who wants to come chat with us, email us, find us at Melbourne.com. And we really appreciate the township's support. We've got at least 30 businesses local that are coming to the festival as well. So thank you all. It's a great fundraiser for Melbourne.
And what's the date?
September 18th, the rain date of September 20th.
Awesome, in Taylor Park.
In Taylor Park, yes.
And the time of it?
From noon until 10 p.m.
Great.
It's zone from noon until 6 p.m. So we're really excited because we're decked out of tie-dye. Thank you for your support. We encourage hire Saturday.
Thank you.
Thank
so
you.
much. Thank you. On to reports. People that have report.
Yes, thank you. Mountain Valley Emergency Communication Center is our joint 911. It's fully staffed with 18 full-time and 3 per diem dispatchers. Springfield has joined and is fully integrated, so now there are 4 towns: Melbourne, Summit, New Providence, and Springfield. So moving forward, to assure accuracy, callers will be asked, in addition to the address and cross street, to identify the town, because these 4 towns may have repetitive names. They've added formal classroom training as well as on-the-job sitting and training with a dispatcher. Hopefully, there will be ride-along for fully vaccinated dispatchers as well. This was halted during the pandemic. There will be additional training offered to become a certified emergency medical dispatcher. They will also be able to offer this training to other facilities as a revenue stream. Keely, the assistant director, attended our national night out in Taylor Park. She will also, in the fall, either over Zoom or in person, come to one of our township committee meetings and explain all the other ways Mountain Valley offers public awareness through community outreach and other educational programs. Lastly, they are looking to add a CAD, computer-aided dispatch. So all these things are Mountain Valley Emergency Communication Center is really moving ahead of the curve, and we're really pleased with how things have been going with them. So that's my report. Thank you.
No reports.
Mayor?
Yeah, thank you, Mayor. I want to congratulate Steve Brillo and the Explore Melbourne board on their 1-year anniversary. This week they received their 501c3 designation from the IRS, so that's really a great thing. And they also commissioned a curb efficiency study. And they have a report, tonight we don't have time to go the Explore Melbourne meeting. Taste Buddy at 515A Melbourne Avenue, and Elephant Plate at 346 Melbourne Avenue. They made presentations, and I know that you'll share with me our welcome for these two businesses, and it's just great that we're getting these businesses coming in.
Absolutely.
Yaya, do you have any reports for us tonight?
No report, Mayor.
Okay, thank you. I would like to introduce our Affordable Housing Center, Elizabeth McManus, who's in the room with us tonight. We'll begin this evening with providing a background on affordable housing, along with a public comment period. Please keep in mind that the contents of the settlement agreement cannot be addressed at this time. If approved, an overview of the contents will be reviewed later this evening. There will be opportunity after the vote on the settlement agreement for specific settlement agreement questions. To help facilitate an orderly meeting and to permit all to be heard, well, we'll get to that after. So I'm gonna let Beth present.
Thank you, folks. I'm going to stand just over here so I can look at this screen. Okay. Thank you very much, folks.
Yep,
Okay.
you're right.
If the council, unless you guys object, I'm going to remove my mask just so I can speak a little clearly, and hopefully everybody can hear me both in the room and also on Zoom. So the first thing I want to do, as the mayor said, is give a little bit of a background about affordable housing, about the system that we have in New Jersey, just so that folks have a good basis for what the council is going to be considering this evening with the settlement agreement. So where I'd like to start is essentially, what is affordable housing in New Jersey? Fundamentally, it is housing units that are reserved for low and moderate income households. That means households or housing units that are most often deed restricted for a minimum of 30 years to ensure that they can only be occupied, whether they are for sale or for rent, by households that meet one of the various income guidelines that I have up on the screen. And so what you can see is the three different types or levels of affordable housing. That's moderate income, which is 80% of median income, low income, that is 50% of median income, and very low income, that is 30% of median income. And just by way of example, I wanted to share a couple average salaries here in New Jersey that based on those average salaries would qualify for a low or a moderate income unit here in Melbourne. So consider, for example, that home health and personal care aides, their average income is just shy of $29,000. And based on this chart that I have on the screen, that means that that average income would qualify, that person with the average income would qualify for a low income unit here in Melbourne. Similarly, nursing assistants have an average income of about $33,000. And cashiers have an income of about, on average, about $27,000. And then the last example I wanted to give is waiters and waitresses, which have an average income of about $30,000 a year. And so these are all examples of occupations that we have here in Melbourne, as well as in the surrounding region, that qualify for low and moderate income housing. And so what this really translates to are restricted rents and sales prices. So if you qualify for a low or moderate income housing unit rather, this means that your rent will be held at one of these approximate values that I've placed up here. So a 2-bedroom rental unit that's affordable would rent for between $600 and $1,300 a month. And that pretty significant range is based upon the range of the income, the very low, the low, and the moderate income I just went through before. And similarly, a 2-bedroom for sale affordable unit would be sold for approximately between $70,000 and $175,000. And again, that's dependent on whether it's a very low, low, or moderate income unit. So there is a lot of history to affordable housing in New Jersey. And I will not go through all of the details because that is a presentation in and of itself. But I think it's important that folks understand why we're here tonight, why Melbourne has been tasked with addressing this monumental challenge. And frankly, it all goes back to 1975, when we had a very critical court decision for the development of New Jersey. And that is referred to as the Mount Laurel 1 decision. And it, at its most core level, it is the New Jersey Supreme Court finding that every municipality in the state has a constitutional obligation, as in related to our New Jersey Constitution. They have a constitutional obligation to provide opportunities for low and moderate income housing development in their community. That case, there was another iteration of that case, essentially, Mount Laurel 2 decision, again, New Jersey Supreme Court. And at that point, the court provided some more detail. And rather than just simply this amorphous obligation to create opportunities, it identified that municipalities should have specific obligations. So an actual number of affordable housing units that need to be created or need to be given an opportunity to be created within their municipality. And so what that did was it really created a scramble for municipalities to try to come into compliance, to create affordable housing plans that would provide for the correct number of affordable housing units. What it really led to is frankly chaos. And so the New Jersey legislature finally stepped in 1985 and gave us the Fair Housing Act. And that's important because that's the act that everything that we're working on today is based upon. So when I research affordable housing in New Jersey, I'm still going back to this Fair Housing Act that started and has been amended several times, but started in 1985. That Fair Housing Act also created the Council on Affordable Housing. That is the state agency, often referred to as COA. That's the state agency that is supposed to implement the Fair Housing Act. What does that mean? It means they're supposed to create affordable housing obligations. They're supposed to create rules so that towns can figure out how to comply, how to meet that obligation. And they're supposed to provide administration and enforcement. They are the intended recipient of municipal housing elements, and they would review them and presumably approve them or work with the municipalities until they were eligible to be approved. That worked pretty well for from about 1987 through 1999. COA issued rules, they issued obligations, they approved municipal plans, and things really started to fall apart in 1999. It started with a delay in the agency issuing rules. And then they issued rules in 2004, also in 2008. However, they were struck down time and time again. The agency was tasked with developing new rules, and it all came down to a moment in 2014 where there, for reasons I won't get into this evening, but the bottom line is the agency could not adopt the rules. There was literally a 3-3 tie, and what that meant was the rules were not adopted. There was some litigation afterwards, and that's when we had our 2015 Mount Laurel 4 decision. And that is a key point in the process that we're in today. Because in that decision, our New Jersey Supreme Court essentially found that the state agency COA was no longer functioning. They couldn't be trusted to produce those obligations, to produce the rules, and to do the administration of municipal housing plans. And what the Supreme Court said was, on one hand, they said, please, state agency, please fulfill your role. But if or until that happens, all of this needs to work through the New Jersey courts, through superior courts. And so what that means is instead of Melbourne working with our intended state agency to produce an affordable housing plan that would be compliant, we are now forced to work through the courts. That means we have to work through this process that I'm going to go through in more detail this evening, and do so through the courts, which is a more lengthy, complicated, and frankly, costly process to municipalities. But what does all this mean besides simply the courts stepping in? What it means is that affordable housing in New Jersey is state mandated. It means that we have direction from, first from the New Jersey Supreme Court, then from the state, well, from the legislature through the Fair Housing Act, and then through the state agency, COA, when they were functioning, and now again from the courts for municipalities to produce compliant affordable housing plans. And it's so important that towns do this because there is a major incentive. There's a significant incentive for doing so, as there's a cost for not doing so. And that cost is a lack of control, and it is being potentially subjected to builder's remedy litigation. And that's something that a lot of municipalities, including Melbourne, is familiar with. And that is simply, could be quickly summarized as a developer stating that a municipality has not fulfilled its constitutional obligation to provide low and moderate income housing. That developer then offers to provide assistance to the municipality by creating an affordable housing development. Those developments look different depending on what town you're in, but the characteristic that seems to tie all of them together from Essex County all the way down to Salem County is that it is a building or buildings that is too much for the municipality's vision for that site. It's too dense, too tall, too big, too much. And because the developer has presumably been successful in showing that the municipality is exclusionary to low and moderate income households, they are not providing this opportunity that is required by the Constitution. The developer is oftentimes successful in seeking approval, court approval, and then required municipal approval for that building or buildings that are just simply too large. And that very significant incentive is the thing that typically drives municipalities through this process. Because to be subjected to builder's remedy litigation, it means a fundamental loss of control over your municipality. It means your zoning is irrelevant. It means your master plan vision is irrelevant. And then frankly, if you do go through the builder's remedy process, what's typically required is that you produce the housing plan anyway. And so there's ultimately no escaping this state mandated requirement to produce the affordable housing that's necessary. And so what I want to be clear about is who we're dealing with in the settlement process. So certainly it's the state of New Jersey from the perspective that they've adopted the Fair Housing Act, but it's also more directly, it's the courts. We're working directly with Essex County courts to help administer this process and then hopefully to approve a settlement agreement that the municipality may enter into and approve a housing plan that we may adopt to enforce or rather implement that settlement agreement. But beyond that, we're also working with advocates, and the principal advocate is Fair Share Housing Center. They are a critical organization in this process here in Melbourne and in literally every other municipality in the state that's gone through this process. They are essentially a court-appointed or court-recognized interested party, and that means that they are on the other side of the table in mediations about what the municipality's affordable housing obligation is and how it will be satisfied. And just for a little context in the history, they're the organization that has pushed the court to ultimately issue that 2015 Supreme Court decision, pointing out that the state agency was not fulfilling its role. In addition to mediating with Fair Share Housing Center, we're also working with the special master. That is a planner. Almost always a planner, but here in Melbourne, a planner that has been appointed by the particular judge to assist him or her in this process. That means that they serve as mediator, they serve as a guide to the municipality in crafting the affordable housing plan. They also provide assistance to the developers if they're involved in the case, and of course they assist with the judge's evaluation of the municipality's action and their fair share plan. And then last, but certainly not least, is obviously the municipalities, as it is our obligation that is assigned and our responsibility to satisfy that obligation. So we started in 2015 when I said we had that Mount Laurel 4 decision issued. Since then, approximately 330 municipalities in the state have gone through this process. They've filed they've filed what's referred to as a declaratory judgment or otherwise become involved in the process, perhaps through builder's remedy litigation. There are all but about 5 towns, including Melbourne, that have settled. And that's critical to understand because I think that's part of the reason why this process, why the settlement has come to a head so rapidly. One of the things we'll talk about is what happened in the last month or so with the courts and increasing pressure on Melbourne to go ahead and settle its housing plan. So in 2015, perhaps uncoincidentally, the township created its first affordable housing project, and that's actually referred to as the Upton Inclusionary Development, or the Upton. It's on JFK Parkway, so folks may be familiar with it. In 2018, this municipality was actually subjected to a builder's remedy litigation, and that's for the Silverman site. It's at or sometimes referred to as the Woodland Chatham site, based on the intersection that the site sits upon. And so that's a great example of what happens with the municipality. We were subjected to a builder's remedy. We did ultimately settle with them, but that's an example of where Melbourne faced this challenge with the developer. And that really kicked off this process for us. Once we got through the immediacy of the builder's remedy, the municipality was able to get immunity from future builder's remedy litigation, which is truly important to any town that's going through this process. And from then, we began our mediation. We began our settlement process working with Fair Share Housing Center. And from 2018 into 2019 and through today, our negotiations with Fair Share have continued. It's been, I think I can estimate, been hundreds of hours that have been spent working with the organization as well as the developers that have been involved. Those developers are actually two parties that became interested parties in our process, meaning that they are recognized by the courts, and ultimately the court pressured Melbourne to settle with not only Fair Share Housing Center, but also our 2 interested parties. The first one is Woodmont, and the second one is 249 Melbourne Avenue, sometimes referred to as the Annie Says site. And so it got to a point where the court gave us approximately 3 weeks and said, Melbourne will settle or the township will lose immunity. And it was, that is a very scary proposition for any municipality, especially a town like Melbourne that has at least 2 developers, Woodmont and Melbourne Avenue, that are literally standing there waiting to either have a settlement put in place for their development, or in the alternative, I have to assume to take advantage of the builder's remedy litigation opportunity. And unfortunately, there may have been other developers or property owners waiting as well. The municipality took that direction from the court very seriously, and settlement negotiations were expedited. And as we all know this evening, a settlement will be considered. I want to talk a little bit about the obligation generally. The first thing to understand is that there are 3 components of every municipality's obligation. The first one is the rehabilitation obligation, and that is an estimated number of substandard units in the municipality that are occupied by low and moderate income households. It is an estimate based upon data sources such as the census and the American Community Survey. It is not a reflection of somebody driving through this community and identifying substandard units. The second component is the prior round obligation, and this is the obligation from 1987 through 1999 that COA administered. They calculated these obligations. They put in place rules for municipalities to help satisfy those obligations. That number remains in place and is something that every town needs to address. The third component is the third round obligation. And that is the obligation that addresses that from 1999 now all the way through 2025. It is essentially a 26-year obligation. And it is the time that it applies to is noteworthy because it's so long. What that means is the obligation across the statewide and at the municipal level is really quite large, much larger than we were used to thinking about during the first round or the second round, which I should note are collectively referred to as the prior round. It's because of that 26-year obligation that the numbers have grown. So now I won't go through all the details, but I wanted to put this screen or this slide up because it shows the complication that this township and every municipality has to deal with. So yes, we have a prior round obligation and a third round obligation, and of course the rehabilitation obligation. But for the prior round and the third round, in addition to just simply finding a way to meet the total number, there are a variety of subcomponents of that obligation. It includes things like the 25% rental obligation, 50% family obligation, the 50% family obligation of the 25% rental obligation. There's also income distribution and bedroom distribution. And I should also say a limitation on the number of senior units that can be included in the municipality's fair share plan. So I'm happy to answer any questions about this at some point, but just, I wanted to put this up so folks have a sense that this is unfortunately quite a complicated puzzle that municipalities have to find a way to meet. This slide depicts the various affordable housing obligations that have been calculated for Melbourne. And there's a slide like this for every town in the state, or could be anyways. The numbers all the way on the left represent the obligations calculated by COA in 2008. And those obligations went from, I believe, 1999 through 2018. And the state agency, using their own methodology, calculated a number for the third round in particular, as you can see, is quite low at only 67 units. Now, I should say that obligation, or rather the methodology that produced that obligation, has been thrown out by the courts. That is part of what the court had overturned during COA's attempts in 2004 and 2008. Moving on, we have an obligation produced by eConsult, and that was an organization that worked on behalf of municipalities to calculate municipal obligations. That number, and then next, second to right, is the Jacobson decision. That's an important number because that represents the methodology and then the resulting affordable housing obligation that was determined by Judge Jacobson in Mercer County. Now, her decision technically only applies to 2 municipalities in Mercer County, but it is such a well-regarded decision. It was argued so thoroughly that it has become a number that many municipalities and Fair Share Housing Center in settlements have come to rely upon for determining municipal third round obligations. The number on the right is Fair Share Housing Center obligation. That's the number that their experts produce. Now, I should note that the Judge Jacobson decision essentially decided between obligations being argued by Fair Share and obligations being argued by eConsult. And so, as you can see, her obligation for Melbourne is 1,115 units. And clearly, it skews a bit towards Fair Share, as their obligation was set forth at a little under 1,400, while eConsult's obligation was a little over 500. And so I thought this slide was important because it shows the range of third round obligations that have been calculated by the municipality. And I think it also highlights the importance of why we chose to consider settlement, because one of the benefits of going through the settlement process is typically that a municipality receives a lower third round obligation than might have otherwise been assigned during a trial. So as we see here, I've got a summary of some litigation risks and some benefits of settlement. The litigation risk, as I've talked about, is, I think first and foremost, it's the loss of immunity. It's the loss of control over our planning and zoning, and it's the loss of control over specific sites. And so by settling, we're able to maintain that control. That means that we produce our housing element and fair share plan, we determine the zoning, and frankly, we're not subjected to builder's remedy litigation. As I said, through settlement, municipalities typically receive a lower affordable housing obligation, both at a total obligation and if there's any adjustments, such as a vacant land adjustment. And then lastly, the last point I want to identify for litigation risks is that there have been some municipalities that have decided to go through this process and have decided that they're unwilling or unable to settle with Fair Share Housing Center, and they've decided to hold a trial. And that trial typically has to identify what the affordable housing obligation is and what the plan is to satisfy that obligation. So what sites will be selected, perhaps what densities will be utilized. I can't tell this municipality that any town that has gone through that trial process has actually done so successfully, and that they've come out in a better position post-trial than they would have through settlement. It is a long and a costly and a sort of painful process, if you will. And at the end of the day, the obligation and the strategies, I'm confident saying, are more demanding, more density, more demanding, however a municipality might want to measure it, than they might have been through the settlement process. And so through the settlement, we were able to gain these benefits. And as part of it, it also means that we are settling about 50 years of affordable housing litigation. 50 years meaning from the time Mount Laurel 1 decision came to be in 1975, all the way through the end of the third round in 2025. And so that's 50 years. It means that we are able to put to bed this risk of builder's remedy litigation through the end of the third round. And so with that, that's an overview of the affordable housing process and affordable housing in New Jersey. And I'm happy to answer any questions.
Just before we get to public comment period, Anna, can you give us a background about who you are a little bit more?
I'm sorry.
Oh,
Yes.
all right. Just so everyone knows, where all your wealth of information is.
Yes. Okay. My name is Elizabeth McManus. I'm a principal at Kyle McManus Associates. We're planners down in Hopewell, New Jersey. I've been working in municipal land use in New Jersey in 2001. Most of my time has been spent working for municipalities. And during that time, I've been working on affordable housing since I think about 2004. I think my first plan was in 2005. So one of those first versions of the COA third round plans I started working on. And since then, I think I have authored either as the sole or maybe even secondary author when I was younger of more than 24 housing plans across New Jersey. I am also special master. So one of the roles I talked about for Melbourne is special master. I actually fulfill that role for about 40 municipalities across the state through this current process. So I have more affordable housing experience than sometimes I like to remember.
Okay. So we're gonna start public comment period on just this presentation that was just given to us. To help facilitate an orderly meeting and to permit all to be heard, speakers are asked to limit their comments to 1 3-minute session into regards to this presentation that Mr. Jimenez just gave to us. You will be prompted when there's 30 seconds remaining, and after the conclusion of the public comment period, your questions and comments will be addressed. So as we normally do during public comment at all of our township committee meetings, you'll have an opportunity to ask your questions, and then when the public comment period is done, then Ms. McManus will answer your questions. And we also have the Zoom you're going to bring back so that we can have participation. Please.
Just
protocol, can we, when we speak, can we remove our masks? We want to protocol. Can you hear
So
us?
we will do that, right? So you
Yes,
can
I'm
take
just
your
asking.
mask off when you're speaking.
That's, I just wanted to, everyone that has protocol. Again, my name is Jeffrey Feld, live in Alexander on Short Hills, New Jersey. I had just a few short questions. One, I was troubled by a comment that was made about the court saying, to paraphrase you, you will settle or you'll lose your immunity. And that's a statement I think that had been made in early July, but that was never told to the public when there was reports given to us by municipal attorneys. I'm very troubled by that lack of candor that the court basically say, settle or you're going to lose immunity. That was an important point that was told, I guess, to us in July, but was never told to the public. In addition, when I started appearing for this group in like September, October, I talked about best practices. And in the best practices that come out from the state, it talked about the need for inclusionary zoning ordinance. Based on this town's response, we don't have one. And that was not mentioned in the report, that we haven't been involved. And I think the public also needs to know, with no due respect to you, Ms. McManus gave a proposal to the town on July 6th. And I think everyone should understand how short your involvement has been with this community. I think you were retained at the meeting in July, so you've been only involved in this a little like 5 weeks. And I think you've really brought us up to speed. However, I think the public should know, when you gave us the chart, starting with the original style, the Jacobson report, like the 4 columns, can you tell the public, when we filed our declaratory judgment, what numbers did we use in those 3 categories? Because later tonight, we will find out where we started in April 2018, and where today, on August 17th, where we were. And then there'll be questions, because there are a lot of serious questions. What transpired in the last 3 years? I've been on really focusing on in the last year, but there seems to have been 3 years that you said there were 5 communities. Who are the other 4 communities? So that the public knows who we are grouped with. And that could help us. But I thank you for the overview. But if you could tell us, where we started in April, that'll help us later this evening to understand, did we go anywhere? Where we went? Because I don't know the answer to that. And we're all waiting for that, the opening of the envelope.
Please.
An answer in that question. My name is Dave Cosgrove, 99 Oakview. So the question, I have 2 questions, really. One is, when were you asked to prepare this presentation? When were you first asked to begin preparation? And the second is, the slide you showed us with the housing business. That's nothing new. That's my question. That's years old, isn't it?
Mr. Cosgrove, we're going to do
Okay,
this as we do
that's the
regular
question.
public comment, and Ms. McManus will answer all the questions at the end.
Very good. Thank you.
Okay, thank you.
Jean Pasternak, 342 Hogwart Avenue. I just want to add a little history for Ms. McManus that you may not have been privy to. Public interest advocates and developers filed lawsuits against many municipalities that had not done their fair share. No advocate group or developer filed a lawsuit against Melbourne until April 16, 2018, when the builder's remedy lawsuit was filed by Silverman for the Woodland Chatham development. The Township Committee in 2017 consisted of Ms. Burstein, Ms. Eglow, and Mr. Levy, Democrats, Rosenberg and Tillotson, Republicans. Silverman was in talks with majority members of the Township Committee regarding Woodland Chatham Road development. An agreement did not seem to be forthcoming. Silverman was becoming unhappy with the lack of response. A builder's remedy lawsuit would force the township to allow that development. I wondered, why did no one instruct the planner to prepare and submit a fair share plan to protect the township from an impending builder's remedy lawsuit? The Township Committee of 2018 was Burstein, Lieberberg, Eglow, Levy, Democrat, Rosenberg, Republican. It was reported that Cheryl Burstein spent 2 years of discussions with Silverman regarding his development plans for the Woodland Chatham Road property. During that time, the Township Committee did nothing to protect the township by submitting the township's fair share plan to the court. That failure to take affirmative steps to protect the township ceded control to the builders. This Democrat-controlled Township Committee of Burstein, Lieberberg, Eglo, Levy, and Rosenberg filed a fair share plan 3 days after the Silverman's Builders Remedy lawsuit was filed with the court, resulting in this irresponsible outcome. Thank you.
Anybody else in the room have any public comment at this time? If anybody on Zoom call, if you raise your hand, do you have any questions at this time? Good evening, Mr. Hildner. Hear you.
Good evening. I'm having a little trouble hearing you. Can you hear me?
We can hear you. Yes, we can hear you. well.
Okay. I have one simple question. This covers affordable housing obligation from 1975 to 2025. What happens after 2025?
Thank you.
That's one question.
Okay.
And the other thing is, I have not seen the petition or complaint that was filed for declaratory judgment, but maybe there could be a brief explanation, or what are the parameters of a settlement? What are the elements that must be included in this besides the number of affordable units? What other kinds of considerations are addressed? Since I gather we're not going to hear the details of the settlement tonight. So, but what's kind of the menu?
Mr. Hildner, let me just interrupt you for 1 second there, because as we did mention that there's potentially, like, after we go through this, that the contents of the settlement, shall it pass, will be revealed. So I just want to correct you on that statement.
Okay, that'll be attached. Again, I'm sorry because I'm having a real hard time hearing you, but the settlement agreement will be attached to some kind of consent order, I assume. And if that's the case, what I didn't hear, what you may have just said, is when that will be available. Is that going to be available as part of this meeting, or is that going to be after the vote on whether or not to approve the resolution?
If we take a vote to approve the resolution, the settlement, the contents of the settlement will be revealed. Can you hear me? Is that better?
Yeah, well, that was slightly better, but thank you for.
Okay.
All right. Those are the only questions I have.
Okay, thank you. Is there anybody else on Zoom that would like to make a public comment period? If not, then we will continue on. Okay, public comment is now over. We are now going to refer to special counsel at USAC to explain a little bit more about this process. Mr. Cusack.
Thank you, Mayor and members of the Township Committee and members of the public. There are 2 items that I'd like to address for the Township Committee and the public. One that actually derives from some of the questions that came up, and that is the confidentiality aspect of this, and the Mayor addressed this at the close of the public comment period. The Township has engaged in mediation virtually from the time the declaratory judgment action was filed in 2018 in an attempt to resolve the matter. Those mediation sessions were declared by both the court and the mediator as being confidential. Everything that was done and everything that derived from those mediation sessions, including the ultimate settlement of this case, were all confidential.
Mr. Buzak, can you please speak up so that we can hear you a little bit better?
Yes,
Thank you.
I will do that. And please interrupt me if you cannot hear me. Is that better?
That is better.
Okay. The mediation activities and the settlement agreement that were derived from that is and remains confidential until such time as it is approved by all parties. That was the order of the court and the order of the mediator. If the Township Committee approves the settlement, as the mayor pointed out, it will then become a public document, assuming that the other parties have signed the agreement. And I will leave that to your counsel, Brad Carney, to address as soon as I am finished. The second item that I'd like to address is a conflict issue. It has been placed on the record in the past that two members of the Township Committee have conflicts with regard to this settlement agreement, one being the mayor and one being Committeewoman Miggins. The basis for those conflicts have been made public, and I will not repeat them. It has now come to light that there is an additional conflict of an additional Township Committee member. Committeewoman Aglow has a conflict of interest that relates to one of the sites that is included in the settlement agreement. She is in proximity to the site in terms of residing. Her residence is in proximity to the site. She has lived in that neighborhood virtually all her life and remains in that neighborhood. The impact of that particular development in her neighborhood, and given her proximity to it, will, in her view, potentially affect the property value that she enjoys, and also her neighbors that she's grown up with and have known for years enjoy. Based upon that, she is of the view that disproportionate weight will be given by her to the impact of this settlement on her personal and financial involvement, as well as those of her neighbors, that will prevent her from looking at the entirety of the settlement with all its components as it affects the municipality in a fair and objective way, and to be able to make a dispassionate decision objectively. As a result of that, we now are placed, or the township is placed in the position where there are three conflicted members of a 5-member township committee breaking a quorum. We need 3 non-conflicted township committee members in order to conduct a meeting and in order to act on any business. So it creates a dilemma and a potential overall catastrophe for any further action on this matter. And this would occur whether it's Melbourne or any other municipality in the state of New Jersey. Fortunately, there is a solution and a mechanism by which that catastrophe will be avoided. And for that, I'm going to pass it to the township's general counsel, Brad Carney, who's here as well on Zoom, to explain what that mechanism is and how it is going to be applied tonight. So, Mayor, I'd like to pass this to Mr. Carney.
Mayor and Council, good evening, everybody. I'm here in Kit Falcon's place this evening, and I'm a partner at the firm of Mariziti Falcon. And under a circumstance where 3 of the 5 members have a conflict of interest would mean that there would be no quorum available to vote on the settlement agreement. However, there is in the law a doctrine known as the doctrine of necessity. And that doctrine allows an official to participate in public business, notwithstanding an otherwise disqualifying conflict. And actually, Judge Serpentelli, in a case, Allen versus Toms River Regional Board of Education, held that the doctrine of necessity can be limited in circumstances where, one, there is a pressing public need for action. And here we clearly have that because we have a court order filed and dated August 2nd with the township's immunity expiring at midnight tonight unless the settlement agreement is approved. Two, there is no alternative forum which can grant the same relief. Well, there's not. This is only before, it can only be decided by this governing body, this township committee. And the body, meaning the township committee, is unable to act without the members in conflict taking part, which is true because otherwise you'd be left without a quorum. So in light of the fact that you meet all three elements for the doctrine of necessity to be invoked, I recommend that it must be invoked here, which would allow the full township committee to deliberate and participate in the public business and considering the resolution this evening to either adopt or reject the settlement agreement.
Okay. Thank you for all of that information. So with all of that being said, may I have a motion to approve resolution 21-236?
Motion.
May I have a second? Second. At this point, I'm gonna offer it up to any township committee members who'd like to make a statement before we do a roll call.
Yes, I would, Mayor, if I may.
Please.
First, I want to thank Ms. McManus for the presentation. It was really thorough and really informative. Thank you. We have a very difficult decision to make this evening. When each one of us up here decided to run for Melbourne Township Committee, we all knew this was going to fall to us to ultimately decide and vote on Melbourne's fair share housing settlement or choose to go to litigation. A very long and very expensive ordeal, which we have been told is not a winning move. As former Republican mayor and then turned council member Tillotson said, Melbourne has kicked the can down the road. Well, all of the former can kickers are gone. And now we have the responsibility to do what we think is best for Melbourne. When I was mayor, that township committee had to vote on the Silverman Chatham Road development. Ms. Miggins and Mr. Wasserman were yet not elected. They both spoke about that settlement and how vehemently they disagreed with it for whatever the reasons they had at that time. They were not yet privy to the workings of fair share housing and just how little control the township actually has. I think it's fair to say they see things through a very different lens now. So let me be clear, tonight is not unexpected. What was unexpected was the time frame that the judge and fair share housing put on us in the middle of the summer and with the resurgence of the pandemic. Some of you here and watching tonight may think we had the freedom to publicly share and discuss what happened during the mediation sessions. Mr. Cosgrove, you even wrote to the mediator. I want to stress that I was not on.
Mr. Cosgrove, please don't respond back. We're just,
I want to stress that I was not on nor part of this year's steering committee that worked with fair share housing. After committee members Miggins and Wasserman would meet with fair share housing, the township's lawyers, planners, the mediator, the developers, and their lawyers, I would then hear what was discussed and in essence preliminarily agreed to and what would be brought to the full committee to vote on. I did not have much input to this final settlement. In fact, to the contrary, many of the things I thought should have been in or out were not accepted by some members of this committee. This is not my final deal that we are voting on this evening. This is what committee members Miggins and Wasserman worked on very hard and diligently to reach our fair housing settlement this evening. Thank you.
does anybody, please, let's just remember not to call out during the meeting. Let's be respectful. So, does anybody else want to make a statement?
Mayor, I can go next.
Okay, thank you.
Thank you, Mayor. And as Committeewoman Eglo mentioned, that it's a tough decision. It is more like it's not even a decision. We have to do this, is what I'm getting it as. It's not that we were not we, but even Committeeman Woman Megan's and Committeeman Wasserman being on the steering committee, I don't think we overall had any say. It was pushed on us. When I say us, all five of us, to have to do this or go into litigation. And just for that sake is what my vote will be on. Thank you, Mayor.
Thank you. Um,
Thank you, Mayor. At this regularly scheduled meeting of the Melbourne Township Committee, the committee will vote on a resolution to ratify a settlement agreement on the matter of state mandated affordable housing. The settlement includes a plan that outlines the construction of state mandated affordable housing in the township. Members of the Township Committee and a steering committee dedicated to this issue, along with a variety of Melbourne leaders invited to participate in this process over the years, have had an opportunity to weigh in on this important subject. Just last month, we think the date is July 15th, Melbourne was given an aggressive court-ordered deadline to settle this matter or face significant consequences. The historical context of this subject is important to understand. For the past 38 years, Melbourne, for one reason or another, failed to address and meet its state mandated obligations on affordable housing. As such, the court and other involved parties through pending legal actions recently presented this for the past 38 years, Melbourne, for one reason or another, failed to address and meet its state mandated obligations on affordable housing. As such, the court and other involved parties through pending legal actions recently presented this township committee with the following choices: further litigate with no real chance of prevailing, or negotiate the best possible outcome and settle. In that regard, and as you will hear this evening, this settlement agreement, which reflects many of the township committee's priorities on managing density in Melbourne, represents the best possible outcome for the township. We are here to share details of the settlement with you this evening after being prohibited from doing so by the court throughout the negotiations. Affordable housing is mandated by the state of New Jersey, enforced by the courts, and essentially required by the state constitution. There is no opting out for municipalities. Municipalities all around the state, including neighboring towns of Madison, Chatham, and Livingston, have dealt with affordable housing mandates for years. It's important to understand that the entire affordable housing process, methodologies, calculations, orders, and timelines is sanctioned, enforced, and driven by the courts. You will hear more about other parties involved in the issue from the township's retained experts. But the bottom line is this: every 10 years or so, municipalities are required to meet court-sanctioned affordable housing obligations, which are specific numbers of affordable housing units that a municipality must provide a realistic opportunity for developers to build or face significant consequences. Given Melbourne's long delay in meeting its state-mandated affordable housing obligations, this matter came to a head for Melbourne and the Township Committee just in July. These were our choices: litigate further with little chance of prevailing and risk losing control of the township's planning and zoning functions and existing regulations, setting the stage for even more developments with affordable housing. Or two, settle and maintain control over all development in Melbourne, including state-mandated affordable housing. We also maintain control of the township's planning and zoning function and existing regulations. And with this agreement, Melbourne is at long last able to meet its past and current affordable housing obligations spanning the period of 1987 to 2025. And, as a final note, I will tell you that as somebody that was involved in this for hundreds of hours, in these meetings, we really did the best we could. We worked hard at this, and we really fought as hard as we could for the township. And that's all I want to say about it.
So with that, can we have a roll call vote, please?
Miss Miggins,
Yes.
Miss Saul Eglo,
Pass.
Mr. Vinayak,
Yes.
was that a yes?
Yes.
Thank you. Deputy Mayor Wasserman,
Yes.
Mayor Prupus,
Yes.
Miss Saul Eglo.
Yes.
Thank you.
So at this point, I'd like to again introduce our affordable housing planner, Elizabeth McManus, who will now be providing the overview of the settlement agreement.
Okay, hello again. Well, now we're down to 4 communities in the state that are unsettled, and I'm pleased to see that Melbourne is not one of them. Subject to court approval, I do expect that that settlement agreement will be approved. Just for reference, I don't think there's been one in the state that has not been approved by the court. Thank you. So the first thing, before everybody focuses on the numbers, sorry, I just want to give an overview of what's in the settlement agreement. I'm going to go through a lot of the details, but there are dozens and dozens of terms, and we would be here till about 1 a.m. if I went through every single paragraph. So today we're going to go through an overview, answer some questions, and additional information will be available at a later point. But most importantly, what's included in the settlement agreement? It's what is the municipality's affordable housing obligation? How are we going to meet that obligation? Meaning, what are the strategies? What are the sites that will contribute affordable housing units? And there are typically terms associated with those strategies. Maybe it's simply just the density and the affordable housing set aside, but sometimes there are details about how the site needs to be implemented or constructed, or perhaps when, with timing. And then there are a variety of other terms that deal with compliance. If folks remember, I had that slide that dealt with the rehabilitation and the prior round, third round obligation. And then it went into, there's a rental obligation, 25% rental, there's family obligation, bedroom distribution, income distribution, etc. There are terms throughout the settlement agreement that address those individual components. And then the last topic of the settlement agreement is about the implementation of the plan. So while this is a monumental step for the township, I have to say we're really not done. So we approved the settlement agreement. At that point, and I'm going to go through the details, we have to do a fairness hearing for approval of the settlement agreement. But importantly, the municipality has to take the various steps that are outlined in the settlement. That means things like rezoning and adopting a housing element, fair share plan, and all the documents that go along with that. And so the settlement agreement spells out what those items are and the timing for doing so. And so with that, let's talk about what's in the settlement agreement. So like I said, first and foremost, it talks about what is the affordable housing obligation. And so this slide should look pretty familiar as it goes through the various obligations that have been calculated by the different experts. And so what I've done is highlighted in red and also yellow what the obligations are for the municipality. So what you can see is, and actually I want to, one more reminder, even though I have the COA 2008 numbers there, it's really just for information and background. They are not applicable. They have been overturned by the courts essentially multiple times. So we have the 109 unit rehabilitation obligation. That is the lowest available number, the lowest available calculation. The 261 unit prior round obligation, as you can see, that is the same number calculated by every single expert, and that is because COA actually did that calculation essentially back in the 90s during its well-functioning years. And then our third round obligation is an obligation that is consistent with the Jacobson methodology, that Mercer County decision I went through with folks during the earlier presentation. It was such a well-regarded decision that it has become the basis for a lot of settlements here in New Jersey, including Melbourne. And I think importantly, that obligation of 1,115 units is significantly less than the Fair Share Housing Center calculated obligation. So what that means is for our three components, we have 109 unit rehabilitation obligation, 261 unit prior round obligation, and 1,115 unit third round obligation. So first, and rather quickly, I want to talk about the rehabilitation obligation. This is an important component of what Melbourne is being asked to do, but as we're going to see through the rest of the slides, I think it's a more minor obligation, if you will. So basically, municipalities are obligated to operate or participate in a rehabilitation program that simply provides advertising to residents of the municipality to let them know that if you are income qualified, if you are a low or a moderate income household, you may apply to receive a grant or a loan to rehabilitate your home, to bring it up to code. Think of things like a roof that's in need of repair, steps, or maybe an ADA ramp that's in need of replacement or installation, these types of items. Municipalities in Essex County will participate, including Melbourne, will participate in the Essex County program. The county, just like every county in the state, operates a rehabilitation program to residents within their county, just like Essex. So first and foremost, we'll participate in that existing program. Second, the township is obligated to create its own municipal rehabilitation program, and that is because Essex County, and actually all counties, do not make their program available to renter-occupied households, despite the fact that that is a required component in COA's rules. So Melbourne, like many other municipalities, will have to create its own program available only for renter-occupied households. But the interesting part of our obligation is that we have an opportunity to conduct what's referred to as a structural condition survey. Sometimes it's called a windshield survey. And essentially, that's an opportunity to reduce that obligation from 190 down to a number that is based upon observation in the community. It's a task that must be undergone by building inspector, construction official, staff member of the municipality, where they would literally drive through the community and identify units which appear based on a adopted checklist by the state agency to potentially qualify for rehabilitation. I will say that just because your house has been identified in the survey does not mean that the household is eligible in terms of your income, nor does it mean that if your home is not identified in the survey, that you are not eligible. It's simply another way of estimating the number of substandard units in the community that may be occupied by low and moderate income households. That is an option to the municipality should we choose to reduce that number. Our prior round and our third round obligations for the purposes of this settlement are essentially combined. So we have that 261 unit obligation for the prior round plus 1,115 units for the third round. I think everybody can understand that there is simply not enough vacant and available land in Melbourne Township to build 1,115 affordable housing units plus market rate housing that may be necessary to accomplish that goal through inclusionary housing. And fortunately, there is a process set forth in COA's rules for municipalities such as this, for essentially built out or largely built out communities. It's called a vacant land adjustment, and it is essentially a theoretical or an academic exercise that municipalities go through to identify vacant and developable land and what their capacity is to accommodate inclusionary housing. Inclusionary housing, I want to define quickly, is development that includes a mix of market rate and affordable units. The set aside for calculating the RDP and the set aside that you're gonna see for many of your sites that I'm gonna talk about tonight is 20%. So 20% of those units would be affordable, the remaining would be for market rate. And so we look at these vacant and developable lands. We also have to identify or include in this calculation any lot that will actually provide affordable units to meet the affordable housing obligation. When we collect these lots, we determine what the total capacity is and what the affordable housing set aside of those lots would be. A couple notes on this is vacant and developable lands are defined terms by the state agency and somewhat supplemented by case law. It is not a vacant and developable lot that your council may identify, or perhaps the planning board or the public would identify. Instead, it's a regulated process set forth in COA's rules that any municipality that wants to take a downward adjustment of its obligation is obligated to follow. And so going through this process, it basically splits the affordable housing obligation into two items. The first one is referred to as the RDP. That's the realistic development potential. And that is the downward adjusted number, the downward adjusted obligation for this township of both the prior round and the third round obligation. The difference between that total obligation and the RDP is the unmet need. And there are different requirements applicable to the RDP and to the unmet need. The RDP requires that municipalities identify individual sites that are currently available to produce affordable housing, meaning that they're vacant and they're developable, or that there's a developer standing there ready, willing, and able to redevelop the property. Unmet need mechanisms require a bit less. So rather than having a site that is potentially ready to go, unmet need is typically satisfied through overlay zoning and redevelopment opportunities, potential redevelopment opportunities. So there's no expectation that a municipality is going to meet the entire obligation through unmet need. It's simply obligated to identify opportunities that may exist in the municipality, that may exist for future redevelopment and development. And so we'll see as I go through the individual sites, the different characteristics of the sites that meet the RDP and the different characteristics of sites that meet the unmet need. So what does all this mean? It means that the RDP is 114. It means that we took our large obligation of about 1,376, and through that vacant land adjustment process, we're able to reduce it down to 114 units. And again, that difference between the 1376 and the 114, that's the unmet need. And like I said before, unmet need is typically met through overlay zoning. That's the most, by far, the most common mechanism. So just generally speaking, and then after this, I'm going to go through the sites. Generally, what are the strategies that Melbourne used, or what was the thought process for trying to meet that RDP? First and foremost, we want to use credits. We want to use the affordable housing units from sites that have already been approved. We want to get credit for the approvals that have already been granted so that we don't have to rezone additional sites. So we took credit from those properties, and I'll talk about those in a little bit. We also used all of our available bonus credits. Sort of a nuance of the rules I didn't want to spend too much time on, but there are certain affordable housing units that are eligible for actually 2 credits for every 1 unit that's created. It's capped at 25% of our RDP. This township took every bonus credit that was available to it, because for every bonus credit, it means 1 less affordable housing unit that needs to be planned. Additionally, the municipality discovered there are a couple of group homes in town. Group homes are living arrangements for folks typically, but not always, with developmental disabilities. they are often eligible for affordable housing credit. We're going to take credit for those group homes because again, those group homes which already exist in Melbourne lead to less planning, less new site identification. And then lastly, we wanted to take credit for our settlements with our affordable housing developers. One of the things I talked about during the last presentation was the court's immense pressure on Melbourne to not only settle with fair share, but also with our two developers that were standing there and waiting. And so given the fact that we're required to settle with them, the municipality required that they produce affordable housing so that we could take credit for the affordable units created and thereby reduce additional development that's necessary to meet our obligation. The strategies for our unmet needs are necessary to be a little bit different just because of the nature of the sites and the considerations. First and foremost, and actually I guess this applies to our entire fair share plan, but the goal was really, how do we reduce development in Melbourne? What strategies can we do to reduce the impact of new development on residents in the municipality? How do we simply reduce the number of new units that are zoned for as part of this process? As part of that, or rather, really in addition to that, one of the other goals we saw was to try to stay out of the residential neighborhood. We want to have as little disruption to existing residential neighborhoods as possible. And then last, one of the components of the settlement agreement is adoption of something that's called a mandatory set-aside ordinance. And that is a township-wide ordinance. It does not change the zoning districts, zoning densities, and it does not obligate your planning board or your zoning board to act differently. But what it does do is where the planning board, the zoning board, or this council through a rezoning or a redevelopment plan, where there's an approval through one of those avenues for new multifamily housing, there must be an affordable housing set aside with it. So if a use variance for multifamily housing applies before the Board of Adjustment, the Board of Adjustment is in no way obligated to grant the variance based on this set-aside ordinance. But if they do grant the variance, they need to impose a 20% set-aside of affordable housing. It just simply ensures that the township captures opportunities for affordable housing wherever they become available. So this is our map that identifies the affordable housing sites in the township. Now I'm going to go through each one of them for those of you trying to crane your head to see exactly what's on the screen. But I wanted to put this up, one, just simply for context, but also I think this does a pretty good job of showing that the sites are not located within our residential neighborhood. And instead, we've, to the extent possible, really stuck to our non-residential districts as a way to again, limit the impact on the township. So the first site I want to talk about is referred to as the Upton, or sometimes the Canoe Brook site. This is a site that actually already received approval and is under construction. It's off of JFK Boulevard at 150 JFK Boulevard on block 5303. It's a little over 3.5 acres. And as I said, it's already been approved, and it's specifically for 200 housing units, including 30 affordable units, as well as a hotel and office space. The next site is the Silverman Property, which we had referenced earlier during the presentation, as this was your 2018 Builder's Remedy property. This site, as you can see from the plan, is located at the corner of Chatham Road and Woodland Avenue. And what you can see here is a concept plan that was developed by the developer. It is a mixed-use building. It's going to have a total of 62 units, including 12 affordable units, as well as medical office space of about 10,000 square feet. And this is actually the final image I have. This is the rendering of the property. So next, we have the Wells Fargo site. This too was actually already approved as well earlier this year. This is a property that's at the corner of Melbourne Avenue, Essex Street, and also Douglas Street. It's a little over 1.5 acres. It received approval also earlier this year for 53 total units, including 8 affordable units, and then of course 3,000 square feet of retail space. And this is, did not show up as well as I thought it might on the presentation. I apologize for that, but that is the ground floor plan. You can see the outline of the building on the site. So this begins our new sites. The ones that I've reviewed previously have already gone through the site plan approval, and many of you may already be familiar with them. This new site is referred to as the Annie Says property. It's also referred to as 249 Melbourne Avenue, both in name and also, of course, in its address. It's a little over 2 acres, and this was one of the sites that the court was requiring Melbourne strike a settlement with in order to maintain our immunity into this month. The settlement for this is 150 total units, of which 30 will be affordable. So 30 will be available for low and moderate income. This is a concept sketch of the site. This is just simply the ground floor plan, but it gives you the outline of the building and indicates that there will be structured parking as well as the building located generally along the street. This next property is referred to as the DPW site. And it is, in fact, the DPW site for this municipality. It's a little over 4.5 acres. It's located, as you can see from the map, off of Essex Street. This is, rather than being simply a inclusionary housing project where the municipality zones and a developer comes in and builds 20% affordable and the rest as market rate housing. Instead, this is what's referred to as a 100% affordable development or perhaps a municipally sponsored construction project. And so what the municipality has agreed to do is partner with a developer to construct 75 affordable units. So all affordable housing units on the site. And what that means from an affordable housing perspective is there's more bang for the buck in the sense that we're getting these 75 affordable units without the associated market rate development. More specifically, what will be necessary is that the township consolidate, or if it so chooses, to relocate all or a portion of its DPW on a portion of the site. One other component that is important, or a couple other components that's important to understand about this property is that one of the requirements of the settlement agreement is that we work with Fair Share Housing Center and with our planner, Special Master, on the design of the property to ensure that both the affordable units can be accommodated in a way that will ensure good quality of life for the residents of the site and still provides adequate space for the municipal facility for the DPW. In addition to simply working with them, we've actually got to work with them and do so successfully by the end of this year, by December 31st of this year. If the site, for some reason, is determined that it cannot accommodate both uses, the municipality has an option for will need to really, if the site cannot accommodate both uses, the municipality will need to identify another site by the end of February, by February 28th, 2022. Presuming this is the property, the municipality, once we've been able to get through the design stage, we're going to begin working with affordable housing developers to construct the 75 affordable units. That means that we'll select the developer, we'll work with them on the concept plan, and then we'll work with them to ensure that they get the outside sources of funding, the federal funding that typically provides the financial support for these projects. And so what's important to understand about this site is that, yes, it's more complicated than just simply zoning a property, but it allows for the municipality to retain extensive control over the project in the sense that we'll have direct input on the design of the site. Obviously, we'll have direct input on what happens with the DPW site, but we'll have input on the design, the developer selection, and exactly how they will interact with the municipality and how those site improvements will appear not only from within the property, but also to the surrounding community. Next, we have the Woodmont property site. Now, this site is located generally across from the Upton, also on JFK Boulevard. And so what you can see from this plan is that the site, which is about 25 acres, includes about 5 to 6 acres of developable land. And so what is anticipated, let me rephrase, what will be required is that the developer locate his or her development outside of the environmental constraint area closer to the highway of JFK Boulevard, Parkway, sorry about that. The site will contain a total of 195 units, of which 39 will be affordable. Now, this property is owned by the New Jersey American Water. And so what that means is that it is not as simple as the municipality simply rezoning the site and then the developer can apply for site plan approval. No, there are multiple steps required for the developer to actually gain ownership and the ability to develop the site. They will need to receive approval from the Watershed Property Review Board, as well as New Jersey Board of Public Utilities for the development of this property. That is an application process that the developer will lead and will go through. If they are successful, the property will then be developed with 195 units, or perhaps some variation if seen fit by the state agencies. So it's simply one additional hurdle that the developer must go through, unlike our other inclusionary housing sites that are up for discussion. This first site for our overlay zones is the Canoe Country Club. And so this is an overlay zone. What this means is that the zoning that will be put in place, which will allow for 8 units an acre with a 20% set aside. This means that the golf course can remain in place, it can expand, it can continue indefinitely if it so chooses. However, the zoning will be an option to the golf course should they choose to close. Next is our B2 zone. This is also on, I should say, on Morris Turnpike. This is also an overlay zone. This means that the inclusionary zoning, which will be 18 units an acre with a 20% set aside, is an option to property owners and developers of these lands. This means that the existing commercial businesses may first remain in place, they may expand, they even have the ability to utilize their existing commercial zoning for new uses and perhaps redevelopment of their properties. However, the overlay zoning provides an additional zoning option for developers and property owners should they choose to cease the commercial use and instead utilize the inclusionary zoning at 18 units an acre. But importantly, they'll have to provide 20% of any affordable unit as 20% of their units as affordable. Our next zone is the B2 zone along a portion of Melbourne Avenue. Now, one of the things I think that is important is that this site actually includes one of our inclusionary housing districts as well, sites rather, the Annie Says property. And so this site will receive overlay zoning at 40 units an acre, again, with a 20% set aside. So just like I talked about on Morris Turnpike, developers and property owners can utilize the existing zoning for commercial uses if they're so inclined, or they can utilize the overlay zoning to include residential uses. But importantly, if they choose to do so, they'll have to provide a 20% set aside. Next, we have our B4 zone within, of course, downtown here in Melbourne. This area will be rezoned as overlay zoning, once again, with the option to utilize that zoning at 25 units an acre with a 20% set aside. So the developer will have an option to utilize the commercial zoning or alternatively to work with residential or perhaps mixed use zoning. Next, we have our CMO district in the southern part of the township. This again is an overlay zone. Once again, it's an option in the way I've described multiple times. The zoning here will provide for 18 units an acre, again, with a 20% set aside. And I think last, but certainly not least, we have the Or1 district. This is off of, again, JFK Parkway towards the northern portion of the municipality. It's another overlay zone, so giving developers and property owners the option The zoning in this area is 20 units an acre, with that all important 20% set aside. And so that is the totality of the sites included in our housing plan. We've talked, or excuse me, our settlement agreement. I went through a variety of sites that will named properties, individual sites that will meet the RDP, a couple of named sites that will meet the unmet needs, such as the Woodmont and the DPW site, and then a number of overlay zones. Now, like I said on the outset, this is really an important night, an important decision, but we're not done. The first thing we need to do pursuant to our settlement agreement and the court's direction is continue with the implementation of our two outstanding developers. That's the Woodmont and the Annisette site. That means that the municipality is going to be required to introduce an ordinance in the near term so that we can advance those properties. One note I want to be very clear about on the Woodmont property that I did forget to mention. While the municipality is obligated to zone that property for the inclusionary development that's set forth in the settlement agreement, the developer is obligated to go to the watershed properties review board as well as the NJPCU. If they do not receive the necessary state approvals, the municipality zoning does not entitle the developer to any inclusionary housing or to any residential use. So that is a necessary step in order for them to activate the zoning, in order for them to utilize the zoning that will be put in place. And so that ordinance drafting and adoption will have to be coordinated with not only the developers, but also the court master to make sure that we're all moving in an acceptable direction. Aside from that, the next step is the fairness hearing. We have to have this settlement agreement approved by the court. That will happen in the next couple of months, presumably. That will happen at a formal court hearing. It'll be publicly noticed, and there'll be coordination with Fair Share Housing Center, as well as the special master and the developers as well. Once our fairness hearing occurs and the judge presumably approves the agreement, at that point, it's time for the municipality to really put into high gear its implementation. That means that we have to put together a housing element, fair share plan, and that includes a variety of additional documents. So it's simply taking our settlement agreement and turning those, 5 pages or so of core information into a housing element that's probably 50 pages or more, and appendices that provide support for the individual sites, whether it's the zoning in place or administration documents to show how the affordable units will be compliant. There are a variety of documents that go into that housing element and fair share plan. Now, that document will need to be adopted by the planning board because it's actually a master plan element, the housing elements, but it will also need to be approved by the council as they will issue an approval for it to be submitted to court so that the court can review and approve it. Once we've submitted it to court, we go back to court, hopefully for the last time, and we have a compliance hearing where the court will review and presumably approve our housing element fair share plan. And at that point, we get a very important document referred to as the final judgment of proposal. And that is our court order that says that Melbourne has satisfied its rehabilitation obligation, its prior round obligation, and its third round obligation. And we have immunity from builder's remedy litigation throughout the entirety or through the end of the third round. And at that point, we will have completed the court approval process. But I do want to be very clear that there are a variety of steps necessary in Melbourne's settlement agreement that will be required to follow through between now and the next couple of years. And honestly, that's not unusual for municipalities in the state. Typically, settlement agreements really set in place a variety of steps necessary for a town to really fulfill its affordable housing obligation. And Melbourne's settlement is no different. Then quickly, I talked a little bit about what's in the housing element fair share plan, but I wanted to show this just for information so that folks know what's coming. Yes, it talks about what are the demographic projections, what are the employment projections, but it also goes through, obviously, how we're going to satisfy our obligation, not to mention what that obligation is, and a variety of supporting documents like implementing ordinances and administration manuals to ensure that those affordable units are actually compliant with the applicable rules and we get the credit that we intend to. that, I'm happy to answer any questions.
Okay, thank you for your presentation. We're gonna take a 5-minute recess and then we're gonna come back for public comment. I don't know where. Sure. That's okay. So there's going to be a general public comment towards the end of the meeting. Public comment. Oh, yeah. You're going to do it. Every meeting. Everyone.
I saw those and I did not get to them. I know, and I don't know, we're gonna have to talk about that, probably not tonight, but we're gonna have to talk about it because it's, why don't we email? Because I think the problem is, it's commercial, so I don't know if I can regulate time on picking up on commercial, and we've already been talking to somebody about it, Mr. Carlin has asked about it as well, so I don't think you can regulate that, I think you can, and if there's trees that are on your property, you can cut them. If there's trees that are on your property, you can cut them, if somebody's hanging over on your building, you can cut those branches. But I can't regulate, I don't think we can have the gentleman go look at it, but this is gonna be probably. We can, so I'm gonna.
We can't start till you're
busy
sitting.
with this, but I'm gonna.
She's here.
Yeah.
All right, we're gonna get started. Let's all take our seats, please. Yes, quickly. Okay, actually, we're gonna, 2 more minutes, but we're almost there.
Yeah, thank you very much for giving an opportunity for me to answer those. Um, Let's see. One of the first questions was, what were the various obligations that were set forth by the municipality originally, presumably in 2018? And I have to say, I'm sorry to say, I really don't know. I can say it was certainly 261 units for the prior round obligation, because I can make that assumption because that number had been set by COA in years past. And every municipality, to my knowledge, relied upon that in stating what they believe their prior round obligation was. A lot of municipalities cited the COA obligation, for example, the one that I had put up on the screen. That may have been the case because none of the other, that's all I can say. I don't want to make an assumption. So I really don't know the answer to that. Another question was, what are the other municipalities that are unsettled? I believe they are Alpine, Randolph, Wayne, and Englewood City. Next, there was, when was I asked to prepare the presentation? I don't have the exact authorization date, but I'm going to say it was approximately August 1st. Another question was, when was the affordable housing obligation produced? The various obligations set forth by the different experts. The obligations that I showed on the screen were produced between 2016 and 2018. I will say that those are just a sample of the calculations that have been done by various experts in the state. But I think the majority of them were done really between 2015 and 17, but the ones I showed were a little bit more recent. Another question was, what happens after 2025? And that is, well, 2025, specifically July 2025, that is the end of the third round. Assuming that there's no change at the state, meaning that there's no change to the Fair Housing Act, that the Council on Affordable Housing has decided not to issue new rules, not to calculate affordable housing obligations. Unfortunately, what's going to happen in 2025 may be similar to what happened in 2015, which is municipalities being forced to go to the courts to determine what will be their fourth round obligation and how they will satisfy that obligation. I think it would be much more streamlined because of all the case law we've gained between 2015 and now, but nonetheless, it's going to be another court process for that fourth round obligation. And that fourth round obligation will not be a 26-year period like we have for the third round. It should be a 10-year period from 2025 through 2035. And then there was I think the last question I had noted was what's included in the settlement agreement, but I think I've just answered that in some detail.
Yes. So we are now going to open public comment period specific to questions on the settlement presentation. To help facilitate an orderly meeting and to permit all to be heard, speakers are asked to limit their comments to 1 3-minute session specific to the settlement presentation. You will be prompted when there is 30 seconds remaining. After the conclusion of public comment period, your questions and comments will be addressed. So again, everyone will have the opportunity to make a comment or ask a question, then we'll close public comment and then we will address them. So if anyone would like to make a public comment.
My name is Jeffrey Phil. I want to thank the planner for the presentation. I just ask as soon as possible to get that slide deck on the website immediately. Now that the settlement agreement has been approved, get the settlement agreement on by tomorrow, by both of them. It's imperative that the public sees it, especially when the public starts hearing about the redevelopment of the DPW site. Goes back to 2008. That was rejected by a majority of the people. We do not talk to the people about it. And when we had a public session about redevelopment, I think it was last 2 or 3 weeks, this gentleman's partner talked about that we still had to go back to the public about to talk about the development of the site. Just feel like I'm playing 3-card Monte. Things are being shifted around. That's just my personal opinion. But please get the information out. We didn't even know that there was going to be a presentation around 4 o'clock today. There's questions about due process. These are basic constitutional issues. That when the people would know that this thing, what we're going to do today, you're finding it for years. most of the public did not know that, one, there was going to be a presentation, and two, that they'd be able to participate virtually. You have to start thinking about the state and federal constitution.
Anybody else want to make a comment or ask a question?
Thank you. David Cosgrove, 99 Oakview. But yeah, I did want to make a statement, to the five of you, although Sanjeev is still by the Ethernet. I'm very disappointed in the way you've acted, in the way you've kept this secret. All of you, all five of you ran on a platform of transparency. Mayor, you ran on one of your legs of your platform was customer service. And I remember giving that speech, at the presentation. And that hasn't happened yet. In fact, the KPI that I see from this town is try to hide everything, try to make it so the citizens can't comment because they don't know anything about what's going on. I keep hearing you folks say, we can't talk about it, we can't talk about it. Everybody else in the state talks about it, not you. Cranford, I sent you a link, a video link to Cranford. They gave at least 2 public sessions while their settlement agreement was a draft. So the citizens would know what's happening. I can ask you that question perhaps too. Name a town that you've done work for that did what this town did, not hide stuff. Now, we had 3 people now who have disqualified themselves. None of those disqualifications were the reasons given for those disqualifications was recent. My understanding, Maggie, was your disqualification was because of Canoe Brook. You've been a member for there years, or your husband has. Tara, I don't know, all the details of yours other than it's, I guess, a relative who rents space from somebody. Diane, tonight, gives a reason saying her value of her house will go down potentially because of this. In connection with the Silverman project, you folks told us that the values of our houses would not be affected at all. Annie Sass has been known by this town as an issue for a long time. The motion that they filed to get into this case was on 4/28. Yet all of a sudden tonight, for the first time, we're seeing a disqualification of some sort because of that. The other question I have, you've already voted on it, so you've passed this unanimously, the settlement agreement. And my question that really is one for you to think about tonight, which is, did you even read the settlement? And by reading it, I don't mean just quick paging through it. It's probably a 30-page agreement. And the question is, do you understand what you signed? And we know that's a problem because with Silverman, we found out later that you folks did not understand what you, the ones who voted, did not understand what you voted for. Thank you.
Mic's not on, hasn't been on.
Happen.
It's on.
So get closer.
I can't, there's the podium in the way, sorry. The big lie of this township committee is out now in the open, and I mean it, a big lie. We residents have been treated like mushrooms, kept in the dark, and now we have this imposition of a whole new Melbourne Short Hills. None of us had one word of input to. We had no say at all. You've listened to your benefactors. Look at your ELEC reports. Who gave? Anybody here? This side of the room has a few people that stand to win big, and this side is going to lose big. You damn well know it, and that's why you kept us off this podium, giving comments and giving input all this year since you took over as leader of this township committee, Ms. Prupus. The developers are licking their chops, and we're crying. Thanks a lot.
All right, does anybody else have another comment? Question for Matt, Hannah?
Harry Heller, 56 Byron Road. I expected even worse to come out of this. I think there are certainly some things that are short. I think there's long. Having privy to the 2018 submittal by the Township Committee state, I think we're coming out with more or less the same number that the state required at that time. I'm not sure. Comment. Just to see that, Richard, and to imagine you guys, I'm sure are, we, the town, submitted 0 units to Affordable Housing Council at that point. I don't know, and maybe this is a question, whether that had any impact on the number that we needed to settle on, as well as the last 5, 10, 25 years not complying with it, we upped in 5, 6 years ago. Question, again, can be answered later. Are we able on all DPW site, mixed-use sites, are we eligible to do area need and get a pilot? I think we are at 6,000 residential addresses now. That is known. I think we're adding about 1,100 total housing. That's separate from any fair market rate. Didn't hear any mention of height. I'm not sure if that's part of any of the considerations that were given. Annie says we know that height is. Certainly would like to know, or if that's being left open to the town to receive a plan. I think just like to know the process. You mentioned the hotel built at the mall. The plan that I saw, is that now as an overlay zone, allowing that developer to come back and put residential there rather than a hotel? I'm guessing the mall and everything else on Kennedy Parkway, down in Brad Street is leaving. The office buildings, Short Hills Hilton, to my knowledge, is still closed. I'm not sure if that's eligible to become apartments, as well as the Short Hills Mall. I think it was either 18 or 20 units per acre. I guess the potential is that we may have hundreds, if not 1,000 units if someone wanted to come in at the acreage at 20 units per acre, at some 20% of those units. I think there were some questions in there to answer, allow them to answer.
Just a moment, should we take the council call? Oh, sure.
Unicorns 36 Hawthorne Road. Just a quick follow-up. Just a quick follow-up question to what Carrie said. I'm also wondering, the developments are sort of a done deal, but what control, when he talked about the height of the development, what other control the town may have over how these developments are done? I'd like to know that. Thanks.
Mr. Schofield, you can unmute yourself. Mr. Schofield, you can unmute yourself. Or we'll come back. Let's move on. Mr. Sotnick, would you like to unmute yourself, please?
That was by mistake. I'm not supposed, I don't want to speak.
Okay, thank you. So, does anyone else want to make a public comment as it pertains to the settlement? Okay, public comment is closed. Ms. Janice, would you like to address the question?
Yeah, I'd be happy to. Let's see. I think the first question was essentially, what other municipalities operate like this in terms of transparency when we're in settlement agreement negotiations? And one of the things I have noticed throughout this process since 2015 is I don't see municipalities revealing details of ongoing mediation, with whether it's discussion about what the obligation could be, what the negotiations are regarding the obligation with Fair Share Housing Center, or the density for various affordable housing sites. Municipalities, due to litigation, really are very much prevented from sharing the details of those mediations in public. There was another question asking whether or not our previous submittals or perhaps the lack of previous actions on affordable housing impacted settlement and our affordable housing obligation. I don't think that the previous submittals to the municipality may have made to court, perhaps suggesting what its affordable housing obligation should be back in about 2018. There's no reason for me to believe that that would have impacted our eventual third round obligation of a little over 1,100 units. Those two actions seem to be very distinct and separate from what I've seen here in Melbourne, but also what I've seen in 50 other municipalities that I can think of off the top of my head. In regards to whether the municipality's lack of previous actions on affordable housing, whether that may have impacted our settlement, I think it does. And there's an example with the Silverman site, for example. That's an example of where the municipality had existing units sort of in its pocket. Yes, it was a builder's remedy, and that has its own implications. But at the end of the day, the municipality was able to gain affordable units that then contributed towards our affordable housing obligation. If we had been through this process in the past, we might have had affordable units that could have contributed towards our RDP or zoning already in place, or units already in place that would have contributed towards our unmet need. And so it's conceivable that would have resulted in reduction or a change in the strategies set forth in our plan. There was another question about whether the municipality can utilize redevelopments and presumably offer up pilots. The answer to that is yes, but there is a caveat. The township is obligated to implement the zoning set forth in its settlement agreement. If we need to take care of that, we need to do those actions in the court-required timeframe. But if in the future the township decides that it would like to utilize redevelopment to achieve certain goals, we can take that action in the future. Importantly, that redevelopment needs to produce the same number of affordable units as the underlying zoning would have, but yes, we have that flexibility. There was another, I don't think this was a question so much as there was an insinuation of around 1,100 affordable housing units. And this is something I want to be really clear about. This obligation, our affordable housing obligation, is not the nearly 1,400 units of the prior rounds and the third round. That is not the number of affordable units that are required to be created in this municipality. Instead, we took a vacant land adjustment and we are able to reduce the number of units that must be provided through this realistic opportunity through site identification by more than 1,200 units, from that 1,376 down to 114 affordable units. Yes, we have unmet need mechanisms that provide for zoning and affordable housing opportunities beyond the 114, but that is perhaps the most critical piece of this obligation, is that our obligation, the most important, the most strenuous type of the obligation, was reduced by almost or over 1,200 units. And as a result of that, that means that we were able to reduce the density in the municipality. We're able to reduce the impact on our infrastructure like roads, and we're also able to reduce the impact on our schools. I mean, I think we can all understand that less development means less impact on this critical infrastructure, including schools. And as part of that, I also want to be really clear that in order to achieve these densities, which are, the 20, the 18, et cetera, units an acre, these densities are lower than they would have been as a result of this municipality's agreement to do the 75, 100% affordable unit project at the DPW site. That direct and sort of guaranteed production of affordable housing units allowed us to reduce the density throughout the township and throughout our overlay zones that I went through for the unmet need. There was another question about height. I think it was specific to the Annie Says property, and I'll just say that that building will be 4 stories. There was another question about the Upton, asking whether the hotel and presumably the office space is included in the overlay, and no, it's not. The Upton received approval for residential use on their property in addition to the hotel and the office. And so that hotel, as well as the office, is not subject to any zoning changes. And then there was another question, and I'm sorry if I didn't get this correctly, but I think there was a suggestion that the mall was subject to the overlay zone, and I want to be very clear that it is not. The Or1 District's overlay zone is actually the land across the street from the Short Hills Mall on the existing hotel, not the Upton Hotel where the residential is located, but the existing hotel and office space over there. And then the last question, I believe, was about control over developments. So as I said, the municipality is obligated to introduce ordinances in the near term for Woodmont and the Annie Says property. Those were our 2 outstanding developers that we're required to settle with. As part of the court's direction, we have to do those ordinances, and we have to do them in coordination with the developers, essentially. We have to find a way that Melbourne can be as happy as possible and the developers can be as happy as possible, and then the special master will support it, and presumably the court will approve it. So that's somewhat of a team effort. However, for all of the other unmet need zones like the B2 or the CMO or the Or1 District, those are zoning ordinances that will be developed by this municipality. And so while we are required to make sure that the densities we've agreed to can be accommodated, this means I can't, for example, rezone the B2 district for single-story buildings only. But as long as we provide for the density through appropriate building controls like setbacks and building heights, the municipality has the ability to regulate all other aspects of the development. That means that we can regulate the building setback, we can regulate site improvements, we can regulate building architecture as well, to the extent permitted by the municipal land use law. I have to add that caveat, but all of the typical zoning that we would do for a new site or for a redevelopment opportunity, we're going to be able to consider for the various unmet need zones. And I think those are all the questions we heard.
Okay, tonight we have to discuss the audit. Copies of the audit in full are available in Town Hall upon request and have also been posted on our website. Our auditor is available this evening if there are any questions, and I would like to introduce her. Valerie Dolan is here with us tonight. Hi. Do you want to provide a brief overview? Great, and take any questions from. Just wanted to say goodbye.
I wasn't sure if I was supposed to leave, so thank you. You're more than welcome, walk right in.
I just wanted to thank
I was like, you've done more talking tonight than I think in a long
Yeah,
time, so.
Thank you
Thank you
for
very much.
all the education tonight.
Okay.
Yeah.
Thank you very much.
Thank you.
Good night. Thanks, Beth. First of all, those who don't know me, my name is Valerie Dolan. I am the partner from Nisabaccia, who is the auditor for the township. I want to say it was a pleasure to complete the audit. And I do want to highlight one of the biggest things about it is because of strong fiscal management for many years and a constant eye on your finances, you actually have survived a pandemic, which has caused a lot of towns to be in a fiscal problem. You wrote it out while you were facing a health issue and a pandemic. You were not really feeling a financial problem, which is fantastic. Can't say that for all of our towns, so kudos to you for keeping a strong eye on everything. A few financial highlights as I do want to give you is that your fund balance is about $13 million, which is an increase of about $460,000. So like I said, even with your pandemic, you were. And of that $13 million, about 5.3 of it is being utilized to support the budget that you're currently in right now. Your tax collection rate remained constant at 99%. And you do have money set aside for pending tax appeals in your reserve for about $1.3 million. You do also have some money set aside in some trust reserves. You have a sick leave reserve of about $1.2 million, which funds about 25% of your liability. And you have an emergency reserve, which actually was originally a snow reserve and became a storm reserve, which is now just an emergency reserve of about just under $1 million at $981,000. The one at the parking utility fund balance at the end of the year was about $1.1 million, which is actually an increase of $156,000. But that was actually due to a fiscal decision of yours that you made to not pay down as aggressively on your bond anticipation note for the parking deck. You chose to pay a lesser amount so that obviously there was no revenue coming in, therefore you didn't incur those expenses. That parking deck is currently sitting at just under $4 million. And when you're about, I believe it's 2 or 3 years left before you either have to pay that parking deck off or go out of the short-term market into the long-term market with that debt. You also have outstanding short-term notes of about $5.4 million in the general capital, which is for South Mountain drainage and for the Complete Streets Phase 1 project. That's the debt that you're carrying. I'm happy to report that this year, as it was Jason's last year, we actually have a clean audit with no recommendations. Therefore, tonight you have no formal corrective action plan that needs to be adopted. In the report, we do highlight a few areas that we'd like to call suggestions to management. Those are areas that we find that have tripped up other municipalities or are up and coming things that we see in future years that could trip up you, and we like to highlight them. Some of them are in the area of sick and vacation leave time. That's been a hot topic. There is an comptroller report out there, and they are coming out and looking at policies. We're recommending everybody go back through, double check with your attorneys, make sure that your policy will withstand the comptroller's review. You have some older capital ordinances and some older grant reserves. By all means, it's always good to keep on top of those and review those if you have any other. But those are really it. Like I said, it was a fantastic audit. Everyone should be commended. We can't thank Jason enough for all the years he's helped us get through the audit, but I'm sure as you all have, for him also have been in the finance office. If anyone has any questions, I'll be glad to answer them.
Anyone have a question?
Just a big thank you. And Jason, thank you for all the years you were in Melbourne. We will miss you. You were really part of why we have done such a fantastic job. And Valerie, your firm coming on a few years ago was brilliant. I will take a little credit for that. And your firm has been wonderful. Jason, we'll miss you.
Yeah, and I also want to say that Committeeman Vinayak and I have worked closely with you. We've driven you crazy for the last year. And I just want to thank you for your service to the township. We're at this point, with a clean audit, in large part because of your efforts. And just want to thank you personally and for the township.
So, Mr. Gavloff has been with us for 18 years. 18 years. That is really something. So thank you so much. And we just wish you good luck in your new role. Yeah. Okay. May I have a motion to approve resolution 21-237?
So moved.
May I have a second?
Second.
A roll call vote, please.
Ms. Miggins,
Yes?
Ms. Stahl Eglo,
Yes.
Mr. Vinayak. I believe he may have gotten off. Deputy Mayor Wasserman,
Yes.
Mayor Prupus.
Yes.
Thank you.
Okay, before we do consent agenda resolutions, Mr. McDonald, can you please give us your report for the evening?
Yes, Mayor.
Thank you. I just want to give a brief report to the township and the township committee regarding the progress of the flex parking removal on Melbourne Avenue. The contractor started the flex parking removal on August 9th. Over the first week of work, was mostly dedicated to demolition, in which they have now successfully removed the concrete or the raised portion of the flex parking. Today, they brought in additional crew to start working on drainage. There are a few drainage relocations that need to take place. And then on Monday of next week, it is anticipated that they will start with the curbing. The curb work should take approximately 5 days. However, we are continuing to speak to the contractor and to the construction manager to make sure that all remains on schedule. We have been reassured that it is to be finished by August 31st. In particular, there is the last portion of this project that will be the mill and pave of Melbourne Avenue in the area of the construction. That will be done at night and will be off hours and will result in the full closure of Melbourne Avenue. However, the remainder of this project will be a one-lane closure as they continue with drainage work and curbing. We will continue to keep the public updated via the website and via social media of any changes or, of the progress in terms of the schedule to be completed by August 31st.
Great. Thank you, Mr. McDonald. And I just want to remind everybody who's listening to please support all the businesses in Melbourne Township during this time. Are there any comments from the committee in regards to any of the items listed on the consent agenda? Comments, questions? May I have a motion to approve resolution 21-2213 through resolution 21-235, which are listed on the consent agenda? Motion. May I have a second? Second. Roll call vote, please.
Ms. Miggins,
Yes?
Ms. Stahl-Eglo,
Yes.
Mr. Vinayak, Deputy Mayor Wasserman,
Yes.
Mayor Prupus.
Yes.
Thank you.
Thank you. As previously noted, proposed ordinance 2581-21, ordinance 25-2582-21, and ordinance 2583-21, designating various historic properties in the township withdrawn from consideration of introduction this evening and are scheduled to be considered for introduction at our September 1st meeting. I would like to present an ordinance entitled ordinance number 2584-21, amending and supplementing chapter 7 traffic section 7-20 stop intersections of the revised general ordinances of the township of Melbourne. The proposed amendment to the traffic ordinance is to authorize the installation of an all-way stop sign at the intersections of Cypress Street and Glen Ave and Cypress Street and Myrtle Avenue. These all-way stops have been recommended by the Township of Melbourne Traffic Bureau, the Engineering Department, and the Pedestrian Safety Advisory Board due to their close proximity to the Wyoming School and to further control traffic in the area. I move that this ordinance be taken up and passed on first reading, of the Township Clerk be authorized to have the ordinance published in accordance with law and the item, and for hearing and final passage on Tuesday, September 22nd, 2020. May I have a second? Second. A roll call vote, please.
Ms. Miggins,
Yes?
Ms. Stahl-Eglo,
Yes.
Mr. Vinayak, Deputy Mayor Wasserman,
Yes.
Mayor Prupus.
Yes.
Thank you.
Ordinance 2580-21 is scheduled to be tabled, and Deputy Mayor Wasserman, will you speak to that?
Yes, thank you, Mayor. So the next item on the agenda is ordinance 2580-21 concerning retail food establishment noise, which is passed on first reading at the public meeting of June 1st. At our meeting of July 13th, the Township Committee agreed that additional time was required for further review and research of this topic. I would like the Township Committee to consider a motion to table this ordinance this evening. The adoption of a motion to table would postpone indefinitely the consideration of this ordinance until such time as they are taken up again, either in their current form or amended form, whereupon they would be introduced in first reading. Accordingly, I request that the chair entertain a motion to table ordinance 2580-21.
May I have a motion to table ordinance 2580-21.
Motion.
May I have a second?
Second.
A roll call vote, please.
Ms. Biggins,
Yes?
Ms. Eglo,
Yes.
Mr. Vinayak, Deputy Mayor Wasserman,
Yes.
Mayor Prupus.
Yes.
Thank you.
Does any committee member have any other item of old business to address tonight? Does any committee member have any item of new business to address tonight? Okay, we've come to the public comment period of the meeting. When invited to speak, please come to the podium, clearly state your name and address, and speak loudly so that your comments may be understood by all and properly recorded. There was a properly noticed remote option for those who could not attend the meeting in person. If you called in and would like to comment, please press *6 now. If you're attending by computer or electronic device, please click the raise hand button. All members of the public wishing to speak will be put into the queue to address the committee. Whenever an audience or committee member reads from a prepared statement, please email a copy to the Township Clerk's office at townclerk@melbournetwp.org. To facilitate an orderly meeting and permit all to be heard, speakers are asked to limit their comments to 1 3-minute session. You will be prompted when there is a 30-second remaining. And, okay, I'm opening public comment period.
Good evening. Sarah Sherman, South Mountain Civic Association. I have a statement to read. I have to remind you of a date. August 28th will mark the 10th anniversary of Hurricane Irene, which caused extensive flooding in downtown Melbourne and the South Mountain and Washington neighborhoods. The storm galvanized the South Mountain Civic Association to fight for local flood mitigation and led to the creation of the Rahway River Mayors Council, which now represents 8 towns along the river. Irene was a record-breaking 100-year storm that occurred 12 years after Hurricane Floyd's similar devastating effect on the township. For the last 10 years, the council has worked tirelessly to achieve a solution to flooding along the river. Residents' hopes were dashed in 2018 when the Army Corps of Engineers rejected a plan that had been approved initially but later denied because it relied on weather forecasting. Undeterred, the council went back to work on potential solutions acceptable to the board. More recently, in addition to the council's efforts, we have been supported by New Jersey's congressional delegation with leadership from our senators and Congressman Tom Malinowski. Thanks to their work, the 2020 Water Resources Development Act includes a provision to make Rahway River flood mitigation a national priority, and Congress directed the Corps to find a fundable solution. This year, the council, along with Essex and Union counties, reached consensus on the Flood Protection and Resiliency Plan, which would lower river elevation in towns from Melbourne to Rahway. The plan is now being studied by the Corps. We are relying on the advocacy of the NJDP governor, state legislators, and mayors, and we are pressing for a positive outcome for the consensus plan. I would like to quote an editorial from the item of Melbourne Short Hills from September 15, 2011. Quote, without a serious long-range program and the township's serious financial commitment, you'll be running pictures of Floyd, Irene, and some new storm of the century, some September, sometime soon, within the next decade, unquote. We have been lucky, but luck is not enough. Superstorm Sandy was not a flood event, but we endured days of discomfort and inconvenience. We still need to mitigate flooding along the Rahway River, and there is no plan B waiting to be unveiled. This is it, and no solution is not an option. We are hopeful that 2021 is the year that the consensus plan is approved by the Army Corps and becomes a reality. Until then, we hope for an uneventful hurricane season. Thank you, and thank you for your support.
Long practice of 2 50 Melbourne Avenue. Next to my property is a complex multifamily. I've lived in this property for 50 years. This particular property is exceptional to the rest of the multifamily properties. The garbage collection in this complex is not similar to any other complexes we have on Melbourne Avenue. Every complex uses individual canisters inside of their building. They collect the garbage, they put it up in the front, and it gets collected properly. This building did that for 25 years. In the past 10 years, they have placed a garbage container on the back of the property, which doesn't accommodate the volume. It gets overloaded, it gets contaminated, and after 4 years of complaint, writing a 10-page report to the prior mayor, they eventually decided to take this out of the buffer zone and put a cage around it. Instead, you take the pig, put lipstick on it, and hide it from the public. I sent pictures last night of Barry to Representative Nichols. There are people at night dropping all kinds of things. This morning at 6 o'clock, they were dropping toilet in this garbage container. It's not the first time. Why this building is different than the rest of the complexes on Melbourne Avenue? The place has the accommodation. It's inside of the building. They have put the canister locked the 25 years. This is 50 feet away from my living room, my TV room, and my sleeping room. I smell the garbage. It hasn't been addressed properly. They did some things, but it is not the real issue. The other issue I have with this property, I have the longest borderline with this property. This property is the last commercial property, then it's a residential property. It's nested, surrounded by 5 residential properties. Therefore, I have about 90 foot of back property with this property, with my fence. And there are 18 trees in the back of this property. The height of these trees is 3 times bigger than the 3-story building. And I have complained for years and years that these trees should be cut down. It should be cut down so it won't hang over the doctor office, over my skylight, over my. I have changed 2 fence fixes. I have changed 2 skylights. And anytime I have complained, they say, pay for it. It's okay. And they are not my trees. These trees pose the same danger as the trees on the sidewalk, which town probably cuts them down. These trees need to be cut down, otherwise they're public asset. They can come down on Melbourne Avenue.
Thank you.
And I appreciate it.
Thank you for bringing this to this meeting.
August 28th is a very important day. Besides the hurricane, it's also the 50th anniversary of Martin Luther King's "I Have a Dream" speech. Prior to him speaking, the rabbi from York talked about the sin of silence. And that ties into like the theme that we had today. But I would like to also give a shout out to something positive that occurred last night, where we saw a neighborhood unite in opposition to an application, and that the zoning board allowed the public, the citizens to speak. They didn't shut them down. In addition, the objectors brought an expert who was provided approximately 30, 45 minutes to speak. They talked about the application, how it didn't comply with the master plan, and that same expert tried to speak before this body considering the adoption of the amending restaurant zoning ordinance. He only gave 15 minutes. And but what it showed that when the community talks to their neighbors, they can make change, affect change. We heard about the audit. Yes, you got a clean audit. But people need to read the last part about the recommendation. There was a statement about a paragraph in there about how I found an inconsistency where professionals were being paid in excess of the retention cap, and that matter was remedied because of efforts of the public, not you. In addition, you should look very carefully at the audit about your capital accounts. There's a serious amount of unfunded obligations that we're going to have to pay as the years go on. Approve various projects, but you do not have funding. I think the number might be like somewhere around $6, $7, $8 million. You can't lose sight of it. But I was jazzed by what happened. Because there is a community in this municipality. I just know my neighborhood. 3 fathers will be marrying 3 daughters off in the next 5 weeks. We have young kids going to kindergarten for the first time. We're going to be celebrating. My generation, we're now my neighbors, we're becoming grandparents. And this is something that we had to look at. Today, you disappointed the community. You knew a presentation was going to be given on such a major issue. We should have had more prior notice. And I think that the presentation, she did a great job. I think she might have to be brought back to the community to give that presentation to explain. She did a great job, but people better understand, she only came onto the spot in July. The question is, what happened for 3 years prior?
Okay, let's take public comment.
Hello?
Good evening.
Yes, we wanted to bring new business. I'm not sure if this is the time or if you guys are still doing the public statements.
This is public comment, so you have 3 minutes to speak.
Okay, we just want,
Say your name and your address, please.
sure, it's Rachel Lerner Schachter and we live on Locust Avenue. Okay, so on August 2nd, my son was crossing the street with a scooter and his scooter was struck when a car unsafely passed another car yielding to the child that had indicator lights on. The child was able to jump off the scooter in time to avoid being struck. The incident occurred on Locust Avenue between Ridgewood Ave and Mountain View Road. In the process of working with the traffic department and the Melbourne Police Department and town engineering, we have discovered that a lot of the intersections around the South Mountain District are unsafe and can be improved. In speaking with multiple neighbors on our street, many have experienced multiple incidences with cars passing cars, speeding. Some cars, while turning into their driveway, have almost been hit into as well. As concerned parents of the child and as new residents of Melbourne, New Jersey, where we recently moved from New York City, and myself as a nurse practitioner, we would love to work with the town further. And we've submitted the traffic management form and are plan to attend the pedestrian committee in October. But we did just want to bring this attention to the town committee to make the road safer. And, I know that there's been a traffic study that's ongoing and that we're, looking at other avenues to make our area safer. But we did want to bring the attention to the committee at this time.
Thank you.
Thank you.
Alex, take note of that and we'll talk about that.
I'm sorry, Mayor, could you repeat?
Oh, I just asked you to take note of that so that we can follow up.
Hi,
Wait,
can you hear me?
Oh, yes, 1 second.
Hold on. Yeah, I will look into, the traffic issues management policy, and we'll make sure it's a part of the agenda for the pedestrian safety advisory board.
Okay. Good evening.
Are you ready for me?
We are.
Hi, good evening. I have to tell you that the audio, and please don't take my time with this, but the audio was horrific and the video, and it was just awful tonight. So my name is Perry Urso, 514 Melbourne Avenue in Short Hills. Here are 5 words which should have guided you tonight. Accountability, the fact or the condition of being accountable, responsibility. Benefit, an advantage or profit gained from something, oversight, an unintentional failure to notice or do something. Representation, the action of speaking or acting on behalf of someone or the state of being so represented. Transparency, the condition of being transparent. In previous meetings, I've read a statement, we make mistakes, we do better. As a wife, mother, and employer, we all make mistakes. We talk about our mistakes, we admit our mistakes, and we fix our mistakes. We learn from our mistakes and we move on from our mistakes. We are smart professionals and grown adults. We are too old not to be able to work reasonably together. Life is too short. In closing tonight, Enzo and I wish to invite all of our committee members to join us tomorrow evening during dinner service between 7 and 9 at Enzo's on Upper Melbourne Avenue for live entertainment. Thank you and good night.
All right, thank you. Tomorrow?
Can I answer the question?
No, not right now.
Oh,
We're
we're
not done
still,
yet.
there's more public people. I apologize.
There's more public, there's no more hands, so public comment is now closed. Almost closed.
I'd like to add, Jean Pasternak, 342 Hobart. I want to add to Jeff's comment about the zoning board of adjustment meeting last night. To the committee, at last night's zoning board of adjustment meeting, there was a hearing on the application by MBK LLC, owned by Mark and Karen Vigos, with the tenant Jersey Mike Subs. The group of residents testified in opposition with the assistance of Peter Steck, planning expert, and led by Glenwood resident Jay Moriali, who made a professional and factual presentation to the zoning board. Both of these gentlemen, as well as numerous others, did the same to this committee on the restaurant amended ordinance, and they were not given anywhere near the amount of time or respect that they were given last night. The group of residents who spoke did make fact-based, compelling arguments against approval of the application. They were heard, they were listened to, and the vote was 6-1 against the application. The chair, Joe Steinberg, handled the hearing professionally and with aplomb, an example to all other Melbourne governing bodies. Please take his lead. It's still possible to listen and hear residents when there is excellent leadership, like Joe Steinberg demonstrated last night. Rich Keller, the planner who testified for the applicant, who's been in town for 25 years, made a comment. He said that Melbourne is really missing the institutional memory of its land use boards, of people like Mary McNett, who was removed from the planning board by Ms. Prupus. He implied, and I agree, that she and others like her are key to ensuring Melbourne's master plan is adhered to, because they remember why things were done in the way they were in the master plan. They are unafraid to stand up to those who try to contravene it. To my fellow residents, let's work together in a bipartisan way, as this group of residents has done. Democrats, independents, and Republicans came together, brought their voices of reason back to township governance, and protected the quality of life in our town, unlike what happened this evening.
Okay, public comment is now done. Would any of the township committee members like to respond?
Yes, thank you, Mayor. I would like to speak to the woman who lives in my neighborhood on Locust about the speeding. The speeding in this town is definitely a problem. We have aggressive drivers. We have people who ignore stop signs. We are having, before school starts, 2 speed humps will be installed in the South Mountain section. I am a huge proponent of speed humps because they work. And I don't think we should ever put the cost of a speed hump in the way of the protection they give us. I spoke to Mr. McDonald recently about more 4-way stop signs near large intersections in the Poet section and near our other schools. But before the 4-way stop sign at Whittingham and Ridgewood, no one stops. And there's speed humps. We have to add more safety, maybe paint within that intersection with reflective light or paint those crosshatches. But I think that our in-house traffic consultant and our professional outside traffic consultant must be tasked with going throughout the entire town and finding more areas like what's on Cypress and Myrtle where that four-way stop sign is going to go. But also follow up, is the four-way stop sign working? Does it need more speed humps, especially around our schools? And I am urging our committee members to allow Ms. McDonald to task our in-house traffic consultant and our other traffic consultant to look and study all of these areas. We could hire 1,000 cops. They can't be everywhere. And we have to keep encouraging our neighbors and ourselves to drive more cautiously, more carefully, and just stop speeding. Because once a child's going to get hit, and this almost happened on Locust, it will be a travesty beyond anything that anyone could ever compare this to. So I implore you, please, we have to be more careful, more courteous, and let's find more places for speed humps, more places for four-way stop signs, and a way to make everything's more visible and more safe. Thank you. Oh, and personally, I love Jersey Mike's. I am so disappointed they will not be coming in an area which is a strip mall, which has a Panera's, has a Wendy's, there's a tire shop. If the residents keep banding together and stopping every potential business from moving in, Melbourne will not be in good shape. We want businesses like Jersey Mike's. And I am really disappointed in what you find so pleasurable, Mr. Feld. Okay, thank you.
Okay. Motion to adjourn the meeting.
Moved.